Okay, you ready, Mr. Upchurch?
Yes.
So good morning, I'm Parole Officer Tricello, and I'm a hearing examiner at the Board of Pardons and Paroles. This is a revocation hearing concerning Reginald Upchurch, inmate number 332491. Today is Monday, December 23rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Can you please state your full name and inmate number for the record?
Reginald Upchurch, 332491.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean for the record on behalf of Mr. Upchurch. Good morning, sir.
Good morning.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose my sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Upchurch, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God upon penalty of perjury.
Yes, ma'am.
Thank you. So we're going to go over the procedure for the hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charge that the state, your parole officer, is bringing against you. I will then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about this purpose or procedure before we begin?
No, ma'am.
We're going to go over the rights that you have for this hearing. And the first one is you have the right to be represented by an attorney at this hearing, and counsel is present for you. You also have the right to receive written notice of the charges of violation. Did you receive those written notices?
Yes.
Or the written notice? Yeah. Okay, perfect. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case at this hearing, and you also have the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes. Yes, ma'am.
We're going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of obedience to the law, the charging officer reported that on October 14, 2024, I received information from a woman named Crystal that you were harassing her over a text message platform known as the WhatsApp. She stated that you had threatened her life and that she didn't feel safe from you. After speaking to you regarding the matter, you admitted to arguing over text messages and that you threatened to kill her and that you signed a written confession indicating this. Based on the information, you violated Connecticut State Statute 53A-62, threatening in the second degree, and 53A-182B, harassment in the first degree. The evidence submitted by the state was identified at the preliminary hearing and marked at the preliminary hearing, and those all remain the same. Attorney Dean, did you and your client receive all of the prior evidence?
Yes.
I know that's perfect. Thank you. And then I also did receive an exhibit from the defense, and that's exhibit 1, a list of parole accomplishments and plans for future parole reinstatement. Do you and your client need any additional time to submit?
We do not. Thank you.
So since we have no witnesses today, it will now be the defense's opportunity to call any witnesses, present evidence, and speak to the charges and any of the evidence submitted.
Thank you very much. As to the charges, I would just argue the preponderance standard has not been met. No arrest has been made from this alleged conduct here, and no warrants have been served. Based on our investigation and research as well, it appears that there are no outstanding warrants. So I would argue that my client is not in violation of the law and ask no finding be made as to that charge. And at the appropriate time, if required, I would like to speak with his background and future plans. Thank you.
Thank you. A moment and I'll get back to you with my findings. Okay, so on charge number 1, I do find that you violated the condition of obedience to the law based on the evidence in support of the charge, which is Exhibit A, D, E, G, H, and I. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you'll have an opportunity to speak to your background, history, and any information at this point. So Attorney Dean, would you like to make a comment?
Yes, thank you very much. My client, Mr. Upchurch, is 37 years old, born and raised in Bridgeport, Connecticut by his grandmother. His support system in the community primarily consists of his wife, Catherine, his grandmother, and his sister, Laura, in addition to a 16-year-old son. Most recently, upon release to special parole in September of this year, Mr. Upchurch was at the Renaissance Maple Street halfway house, and then also at this Community Solutions, Inc. Eileen O'Connor halfway house. Prior to that, he was placed at the Connections Eddie Center halfway house in Middletown. As far as employment, most recently, while he was at the Eileen O'Connor house, Mr. Upchurch was in the process of obtaining full-time employment at Taco Bell. He has a history of working at that placement, and he was unable, unfortunately, to begin before he was remanded. Previously, while on parole, Mr. Upchurch had the following positions. He worked at Five Guys in Norwich. He was full-time third shift stocking at Connecticut Distributors, Inc. He had obtained employment through Costco, but due to a previous remand for the time out program, he was not able to begin there. He was part-time as well at Taco Bell in Meriden for some time, was searching at the same time as well for other suitable work due to an injury with his leg. He also reports that he was doing anger management at J Brother program through Recovery Network while at the Maple Street halfway house. He also participated in the Connections CTPSB, the Problem Sex Behavior Program, once weekly. He also reports IOP from 2020 to 2021 at Recovery Network J Brothers, and that IOP was 3 times per week. He also in 2020 successfully completed New Beginnings at Connecticut Renaissance and also successfully completed outpatient treatment at Rushford. While on parole, he had a good regularity of contact. He is registered to satisfaction on the sex offender registry. He is hoping upon reinstatement to be sponsored by his wife, Catherine, in Willimantic. Her information is included in our exhibit that was submitted. He's amenable to going to a halfway house if it was in Hartford or Middletown, Connecticut, due to the proximity of his support network. He also is hoping to obtain his GED, his OSHA 10 certification, and is open to any job opportunities available, including returning to Taco Bell or a warehouse position. He one day hopes to own his own laundromat as well, and is hoping that taking the right steps now can lead to him going down that path in the future. He's also open to any sort of treatment recommended by the Board of Pardons and Paroles, including the Problem Sex Behavior Treatment or anger management. I would respectfully request that he be re-paroled as soon as possible to establish services in the community prior to his EOS date, which I believe is coming up in mid-2025. He has been incarcerated for a little over 2 months at this point. Yes, but I believe so. Remanded on 10/15. So he's been incarcerated for a little over 2 months, which I think is appropriate. And I would ask that the same should not exceed that. Thank you very much.
Thank you. So I'm just going to take a moment and I will let you know my recommendation. All right, so I have listened to the testimony today and I've reviewed the evidence presented. Based on that, I am going to recommend that your parole be revoked, Mr. Upchurch, and that you serve an approximate 10-month sanction. So that's no new re-parole date because your special parole does end on August 6, 2025. So that's my recommendation that I'm going to send to the board for on January 9th, 2025. And in addition, I'm going to recommend the following conditions in case they choose to lessen my recommendation. So that's no alcoholic beverage consumption, behavioral management program for anger management, No contact with your co-defendant, Theo Peters or Darnell Williams. No contact with the victims, MA, DM, HK, and HB. General no contact with CC, a halfway house placement, just in case. Mental health evaluation, no contact with minors and problem sexual behavior. So again, I'm going to send my recommendation to the board on January 9th. They'll decide that day whether they're going to adopt my recommendation, and the only other option they have is to lessen it. You'll be given notice within a week of that hearing date of what their final decision was, okay?
Mr. Upchurch, if you want to call me on that day, I can let you know what the board recommends, and you and I can debrief basically what happened, okay?
Yeah, can I say something? You said recommend what day?
I'm not recommending any day. I did a 10-month sanction, approximate 10-month sanction. So that goes to the end of your special parole, August 6, 2025.
The board could change that recommendation though. The board has the final say. So we'll know for sure on the 9th what it is they're deciding, okay? So if you want to call me on that day, you and I can discuss what they say, okay?
Also, I don't have a day yet then.
No, she recommended a 10-month sanction, but her recommendation goes to the Board of Pardons and Paroles. They have the final decision. So they will let us know on the 9th what they decide. If you want to call me on that day, I can set up a legal call with your counselor. We can discuss what it is they decide, okay?
All right.
All right, thank you so much.
All right, thank you.
Thank you.
Thank you. Have a happy holiday, Mr. Upchurch. Take care.
This concludes the final revocation for Reginald Upchurch. All right, thank Okay, good morning. My name is Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. Today is Monday, December 23rd, 2024, and I am addressing the case for Mr. Perie Penn, inmate number 293070. The attorney has filed the continuance for this hearing, so as of right now, the case is continued until January 7th, 2025. Thank you. It's too many buttons. Come on. It's not calling, it's going down. Good morning, how are you?
Good morning, folks. Can you see me, hear me?
We can see you and hear you. Perfect.
Okay, can you guys give me 2 minutes because I just saw the person who's be doing this and they didn't have the guy, so I'm gonna call the guy down right now.
Okay, great. And that's Mr. Lugo, correct?
Yep, got you.
Perfect, thank you.
Can you go Lugo to Q? Trying to find it. Looked them up earlier, vaguely remember each two. Okay, disregard that. Okay. Go to disregard. Well, see, hey, can you look up? You'll see video from yesterday. Well, hey, well, she will. 12G. He's in the company. He's got Paroles from the Parole.
No, we had a small thing medical. No.
He's on his way right now. They're waiting for him.
Oh, so you already hit the button?
Yeah. Yeah. They do. Look up what's going on. Because you said, we need it. It's like a normal thing.
No,
There's a thing.
Oh, okay, good. Yeah.
Thank you. Good morning, Mr. Lugo. Sorry we are late. The whole network for the state went down.
I think he can hear you.
Oh, no.
I'm sorry.
Yeah, it's like,
Can you hear us,
So am
Mr.
I.
Lugo?
Yeah, I can hear you.
Okay. Okay, all right,
Yeah.
so yeah, the network went down, that's why we're running behind, okay? But we're gonna get started now. So I am Parole Officer Trisell, I'm a hearing examiner for the Board of Pardons and Paroles, and this is a revocation hearing concerning Jose Lugo, inmate number 375109. Today is Monday, December 23rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office inside Bolsky Correctional Institution. Can you please say your full name and DOC inmate number for the record?
Jose Lugo, 375109.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Lugo.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you, and the state, not you, has the responsibility to prove the allegations by a preponderance of evidence, and that is that the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support the violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything that you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Lugo, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So we're gonna go over the procedure for the hearing. So first, I'm gonna read you your rights. Then we're gonna review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So we're going to go over your rights for the hearing, and your first right is that you have the right to be represented by an attorney, and counsel's here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
So you also have the right to review the evidence against you. Before the hearing, you also have the right to submit evidence in support of your case, and you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So for charge number 1, condition of obedience to the law, the violation details state that on May 17, 2024, Hartford Police Department officers were conducting surveillance in the area of Wethersfield Avenue, Hartford, Connecticut, around 12:30 p.m. During the surveillance, they noticed an individual approach the passenger side of a black sedan located at 19 to 25 Wethersfield Avenue. The same person approached the passenger side of the vehicle multiple times and left. Detectives in the area were directed to approach the area after what was demonstrated. After the unknown individual left the passenger side again, the detectives approached the vehicle and they reported you were standing next to the driver's side door of the Mazda sedan. You attempted to walk away from the scene multiple times since the officers attempted to question. Once the officers attempted to question you, you denied the vehicle was yours. When PD viewed the vehicle, they noticed that suspected crack cocaine was visible in the plain view of the driver's seat of the Mazda. A knotted bag was also viewed containing bundles of white powder that PD recognized as packaged fentanyl. Subsequently, for your involvement, you were arrested for Connecticut General Statute 21A-279A1, possession of narcotics, 2 counts, and 21A-277A, possession with intent to sell narcotics. You were searched and found to be in possession of $1,228 in cash. You were given a court date of May 20th, 2024 on docket H14 HCR 24076391S. You are in violation of your conditions of parole. Number 2, obey all laws. I will obey all laws. And charge number 2, condition of drugs. The charging officer reported that on May 17, 2024, you were questioned by Hartford Police Department officers when being found outside the driver's door of a black Mazda sedan. Suspected crack cocaine was visible in plain view on the driver's seat of the Mazda. A knotted bag was also viewed containing bundle of white powder that PD recognized as packaged fentanyl. These substances were later confirmed by field tests to be positive for cocaine and fentanyl. You were involved. You are in violation of your condition of parole. Number 2, obey all laws. I will not use or have in my possession of control or any illegal drug, narcotic, or drug paraphernalia. The state has filed the following exhibits that have been pre-marked for identification purposes as Exhibit A, conditions of parole. Exhibit B, the remand to actual custody. Exhibit C, the parole violation report. Exhibit D, the notice of parole violation. Exhibit E, the Hartford Police Department incident report number 24-012297. Exhibit F, the State of Connecticut Judicial Branch pending case summary 2. And I'm also going to identify the new evidence that was submitted as Exhibit G, the case information charge disposition. Counsel, and then I also received an addendum, correct?
Correct.
Addendum to the parole violation report on November 27, 2024, and that's also admitted into evidence and reads as follows. On November 26, 2024, Mr. Jose Lugo, inmate number 375109, was heard in court and found guilty on 1 count of Connecticut General Statute 21A-279A1, possession of controlled substance, first offense, and given a sentence of 6 months jail on docket H14 HCR 24076391S. Furthermore, on the same docket, the charges of Connecticut General Statute 21A-277A1A+, possession with intent to sell, 2 counts, and 1 count, 21A-279AA, possession of a controlled substance, for Nolly. Supporting documents have been uploaded into case notes. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
We did.
I have not received any exhibits from the defense. Is that correct?
That's correct. I will be providing testimony regarding Mr. Lugo's proposed sponsor at the appropriate time at the hearing.
Thank you. So we do not have any witnesses today. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges and any of the evidence submitted.
Correct. Yes, on behalf of Mr. Lugo, the first part of the hearing will be relatively brief. That is the correct addendum, and I'm not sure he put on a record. He received a 6-month sentence on the possession of a controlled substance, which is a misdemeanor charge, and he received a 6-month sentence, which my client has served day per day of that. He's been incarcerated since May 17th of 2024. Mr. Lugo, what I just put on the record is correct?
Yes, correct.
Okay. Couple just quick questions regarding the first part. She has the disposition from court. Originally, back in May, when you were arrested, the charges on paper per the police were much more serious, correct?
Yes, it was.
Okay. And it was your position way back in May that it was the wrong individual who they charged with the possession with intent to assault, correct?
Yes, correct.
Okay. And obviously the case has been pending in court. You were initially arrested for those more serious charges, but at the end of the day, on November 26th of 2024, you pleaded out to a misdemeanor charge and you received a 6-month sentence with a max court date, which is already passed. So you've done day per day of that sentence, correct?
Correct.
All right. You don't have any cases pending anywhere else. You're not being held on any other bonds for any other charges, correct?
You're correct. No more cases.
Okay. So I just want to put on the record, I routinely do at these hearings. just because you're arrested by the police for certain charges doesn't necessarily mean you did what the police claim you did. And that's why we have a court process where the state's attorney and his defense attorney take a look at the evidence to see what can be proven and not proven. And this is a perfect example in Mr. Lugo's case where the original charges were relatively serious on paper, but it was just put on the record. He got a 6-month sentence on a simple misdemeanor charge of possession with a controlled substance. So that's my brief comments regarding the first part of the hearing. I do want to be heard about his background at the appropriate time.
Thank you. So I'm just gonna take a moment and then I'll let you know my findings. So for charge number 1, I am going to find that you violated the condition of obedience to the law based on your conviction of Connecticut General Statute 21A-279A1, possession of controlled substance for offense on November 26, 2024, and given a sentence of 6 months jail. In addition, the state provided the following evidence that supports the charge, which is Exhibit A, C, E, and G. And for charge number 2, I do find that you violated the condition of drugs based on the evidence provided in support of the charge, and that's Exhibit A, C, and E. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you and your counsel will have the opportunity to speak to your background and history. So counsel, would you like to make a statement?
Yes, I would. On behalf of Mr. Lugo, my client is 31 years old. He does have 2 children, ages 11 and 6. As I previously indicated, my client was remanded on May 17th of 2024. The disposition from court was a simple misdemeanor charge where he received a 6-month sentence, and he's done that day per day already. I believe in the narrative, his parole officer had recommended a 3-month sanction after he disposed of his cases in court. As I indicated, my client has done 7 months plus. While he was out in the community, he was working at Trader Joe's. He was working 4 12-hour shifts per week at Trader Joe's. I just spoke to him a couple of days ago. He's indicated to me that job is still available to him at Trader Joe's. He is working on completing his GED. He has 1 math class to complete, and he's able to get his GED. So he's been working on it in the facility and while he was out in the community. I did provide you with an address and a phone number and apartment number for his proposed sponsor. I did give that to you on a piece of paper. We don't like to put those on the open record here. So after speaking to him, he has a job lined up. He knows what he needs to do to complete his GED. So 1 class left. Jose, you still on anything you want to add about your background? Or I know you have the job at Trader Joe's. What else are you going to get involved in? If you want to speak, I basically gave her some background information about you. If you want to add something, now's your opportunity to speak regarding your background. Don't talk about the charges. I think I put what I need to put on the record of what the disposition in court is. But if you want to add something about your background, now's your chance to do it.
Yeah, I have 2 daughters. I have a job still waiting for me when I get home. I need 1 more class for my GED. I should be taking the test any day now to complete it. And that's it, really.
All right, thank you.
Thank you. I'm just gonna take a moment. Who is the sponsor to you? Just so.
What's the relationship with Miss Murillo?
Oh, that's my girlfriend. No, her last name is Murillo. Murillo.
We have that. She just wanted to know what the relationship was.
Yeah.
Oh, she's my girlfriend.
Okay.
Thank you.
Sorry, you're a little delayed when I ask you a question. When it comes back, the video is delayed.
Yeah. Y'all late too a little bit too.
Okay.
All right, I'm just gonna take a moment and I will let you know my findings. to let you know my findings. I'm not gonna let you know my findings. I did that already. So I'm gonna let you know my recommendation. So I have listened to the testimony today and I've reviewed all of the evidence submitted. Based on that, I am going to revoke your parole. And I'm gonna recommend a sanction of 1 year and 6 months. And that's with a re-parole date of November 20th, 2025. In the event that the board decides to lower my recommendation, I'm also gonna recommend the following conditions. I'm gonna recommend no alcoholic beverage consumption, no contact with your victim RL, a general no contact with LD, JBL without your parole officer's permission, and no operation of a motor vehicle without your parole officer's permission. I'm also just gonna throw halfway house in just in case if they need a backup plan. So that is my recommendation, and the recommendation is going to be forwarded to the board on January 9th, 2025. On that date, the board can do 3 things. They can either accept my recommendation, they can lower it, or they can increase it. If they choose to impose a sanction longer than my recommendation, there'll be a supplemental hearing. And at that hearing, you'll be notified of it and you'll be asked to be present to address their concerns.
Hey, I just get some clarification for the record. I gotta make sure this record is clear here. So my client received 6 months in court. He's been incarcerated since May 17th of 2024.
Yes.
And you're giving him a sanction of 18 months? Is that what the math adds up to?
Yes, because
Why?
this is a full violation. All 4 of the other violations have been for similar charges, so the behavior is repetitive. And that is just my recommendation. The board can do what they want to on January 9th. And you'll receive all of it in written a summary. Correct.
That's why I'm putting it on the record, Jose, so it's clear. So it's going to the board on January 9th. So it's clear on the record. You were given 6 months in court. You've been in since May 17th of 2025. She just gave you an 18-month sanction. So the board will take a look at the hearing on January 9th.
January 9th, then you get to make the final decision, and you'll be notified within the week after with their decision by written
I'll
notice.
set up a call with you after the board meeting, Jose. I'll set up a call with you.
So this does conclude the revocation hearing for Jose Lugo, and we are going off the record. You're all,
Okay, I'll set up a call with you after the board meets.
you're all set, Mr. Lugo.
Thank
Thank you.
Hey, Trisha?
Hi, we can try to get them logged in.
Yeah, I was just gonna say, do you think you would get this done in 10 minutes? Otherwise, I'm gonna have I was gonna try to have Hannah come up and cover it for me.
Hannah's here. I can try to call them right now and see if they can get them. I did tell the CO 11, but it's possible
okay.
she's working ahead of schedule.
No, that's okay. Hannah, are you okay with covering it?
Absolutely, yeah, no problem.
Oh, okay. Then that works out perfect. Then I appreciate it.
Yeah, no problem. Kathy gave me the notes, so I'll be all set.
All right. Okay, perfect. Thank
Okay.
you.
Thank you.
Yeah, I'll hang out until you get word.
I know we're a little bit early, but, hi.
Is I'm sorry. There we go. Now I can see you. They're on their way down. They just called me if I can send them.
Okay, can we have Cooper first when they do get down, please?
Okay, got you.
Great, thank you.
Thank you. You're welcome. Let's see.
Oh, shoot. Sorry, Ms. Cooper, I just have to call your parole officer. We'll be right with you, okay?
Okay. Good morning.
Morning.
How are you?
Good, how are you?
Fine, thank you.
There goes- Ms. Cooper, I just want to let you know we're just running behind because the whole network was down. So we are definitely behind schedule today, but we're gonna get through it, okay?
Okay.
Officer Marshall, are you with us? I think you have to press *6 to unmute.
You want to try again now?
Who, me? Are you there, Officer
Can you guys-
Barstow?
Yeah, can you guys hear me?
Yeah, perfect. All right,
Okay,
so
all right.
good
Just
morning.
give me just one sec, just 1 sec.
Okay. Let us know when you're ready.
All right. Yeah, I got a charger. Yeah. All right, I'm walking back to my office real quick. All right, good morning. All set. Thank you.
All right, great. So I am Parole Officer Tisella. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning Anthony Cooper, inmate 116577. Today is Monday, December 23rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Anthony Cooper, 116577.
Thank you. And this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean and Parole Officer Barstow. Attorney Dean, would you like to introduce yourself for the record?
Yes, Hannah Dean on behalf of Ms. Cooper, standing in for Attorney Jones. Thank you.
Thank you. And Officer Barstow, can you please identify yourself for the record?
Yep, good morning. Parole Officer Barstow, SMU, New Haven, and Bridgeport.
Thank you. So this is a preliminary hearing, which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been referred to the Department of Correction for diversion for substance abuse programming and treatment. And if by the end of the hearing I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know that the preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. The testimony at today's hearing will be taken under oath. So Ms. Cooper and Officer Barstow, can you both please raise your right hand?
Yep.
Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Yes, yes.
Thank you. So then we're going to go over the procedure for the hearing. And first, I'm going to read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. I will then review and identify the exhibits filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights for this hearing, and the first right is you have the right to be represented by an attorney and counsels here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. In addition, at this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Perfect. So we're now going to review the charges that the state, your parole officer, is bringing against you and the underlying information for each charge. Officer Barcel, can you please read the violation details for charge number 1, condition of reporting?
Yep. All right.
Just started about 5 minutes ago.
Yeah, just give me a sec. Case notes is not working as well as I want it to right now.
Okay.
All right.
Sorry.
I'm okay. Yep.
Happy holidays, ladies.
You too.
Happy holidays to you too.
Yeah, happy holidays. All right.
Happy holidays, also.
Yeah, you too. All right, so reporting, we're gonna go ahead and start.
Yes.
Charge number 1, reporting. You were instructed to report on December 2nd, 2024 at 9 a.m. You were aware of your reporting instructions as you were given your next reporting date during a home visit, which was conducted on 11/18/2024. However, you failed to report. Charge number 1 for reporting. You were instructed to report on 12/4/2024 at 9 a.m. You were aware of the reporting instruction as this writer spoke to you directly via telephone on 12/2/24. However, you failed to report.
Yeah. And charge 2, condition GPS.
Yep, charge 2, GPS. On 6/14/2024, you left your residence at 2:08 a.m. and did not return until 2:25 a.m. Your actions violate the GPS agreement, which states, I will remain at my approved residence between the following hours, 9 p.m. to 6 a.m. On June 15th, 2024, you left your residence at 9:04 p.m. and did not return until 9:20 p.m. Your actions violate the GPS agreement, which states, I'll remain at my approved residence between the following hours, 9 p.m. to 6 a.m. On June 16th, 2024, you left your residence at 4:14 a.m. and did not return until 4:16 a.m. Your actions violate the GPS agreement, which states, I'll remain at my approved residence between the following hours, 9 p.m. to 6 a.m. On June 20th, 2024, you left your residence at 9:04 p.m. and did not return until 9:30 p.m. Your actions violate the GPS agreement, which states, I'll remain at my approved residence between the following hours, 9 p.m. to 6 a.m. On September 12th, 2024, you left your residence at 9:10 p.m. and did not return until 9:33 p.m. Your actions violate the GPS agreement, which states, I'll remain at my approved residence between the following hours, 9 p.m. to 6 a.m. On September 17th, 2024, you left your residence at 11:33 p.m. and did not return until 11:39 p.m. Your actions violate the GPS agreement, which states, I'll remain at my approved residence between the following hours, 9 p.m. to 6 a.m. On September 21st, 2024, you failed to adequately charge your GPS unit as directed. Your whereabouts unknown from 2:56 a.m. to 11:55 a.m. Your actions violate the GPS agreement, which states, I'm responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. On September 24th, 2024, you left your residence at 9:09 p.m., did not return until 9:20 p.m. Your actions violate the GPS agreement, which states, I'll remain at my approved residence between the following hours, 9 p.m. to 6 a.m. On September 28th, 2024, you left your residence at 9:09 p.m. and did not return until 9:30 p.m. Your actions violate the GPS agreement, which states, I'll remain at my approved residence between the following hours, 9 p.m. to 6 a.m. On October 2nd, You failed to adequately charge your GPS unit, making your whereabouts unknown from 8:53 p.m. to 9:12 p.m. Your actions violate the GPS agreement, which states, I'm responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electric outlet for at least 2 hours each day. On November 30th, 2024, you left your residence at 2:34 a.m. and did not return until 2:40 a.m. Your actions violate the GPS agreement, which states, I will remain at my approved residence between the following hours, 9 p.m. to 6 a.m. Charge number 3, drugs. You want me to keep going?
Yeah, keep going. Sorry. Thank you.
Sorry. On June 26, 2024, you admitted to using cocaine on June 22nd, 2024. On September 13th, 2024, you admitted to using cocaine on September 12th, 2024. On September 26th, 2024, you admitted to using cocaine on September 23rd, 2024. And on October 16th, 24, you admitted to using cocaine on October 13th, 24. On October 18th, 24, you admitted to using cocaine on October 17th, 24. And on December 4th, 24, you admitted to using cocaine on December 1st, 24.
Thank you. The state has also filed exhibits that have been pre-marked for identification purposes. Officer Barcel, can you please identify the evidence you have submitted?
Yep. Okay. For Exhibit A, remand to custody. Exhibit B, the parole agreement. Exhibit C, the GPS agreement. Exhibit D, misconduct dated June 24th, 24. Exhibit E, voluntary admission, CN 6802. Exhibit F, the Allied Universal GPS coordinates. Exhibit G, misconduct dated 9/13/24. Exhibit H, voluntary admission, CN 6802. Exhibit I, Allied Universal Violation Report. Exhibit J, misconduct dated September 18th, 2024. Exhibit K, Allied Universal Violation Report. Exhibit L, misconduct dated September 21st, 2024. Exhibit M, Allied Universal Violation Report. Exhibit N, Allied Universal Offender Charge History. Exhibit O, misconduct dated September 27th, 2024. Exhibit P, voluntary admission, CN 6802. Exhibit Q, Allied Universal Violation Report. Exhibit R, misconduct dated October 4th, 2024. Exhibit S, Allied Universal Violation Report. Exhibit T, Allied Universal Offender Charge History. Exhibit U, misconduct dated October 16th, 2024. Exhibit V, voluntary admission, CN 6802. Exhibit W, voluntary admission, CN 6802. Exhibit X, misconduct dated 12/4/24. Exhibit Y, voluntary admission, CN 6802. Exhibit Z, Allied Universal Violation Report. Then Exhibit AA, notice of parole violation, and Exhibit BB, parole violation report.
Thank you. Attorney Dean, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, thank you.
Thank you. And I did not receive any evidence from your office. Is that correct?
That's correct.
I'm willing to move forward without, do you need more time to submit anything?
No, we don't.
Okay. So today we have no witnesses. So at this time, it is the state's opportunity to make a short statement, call any witnesses, or testify with respect to probable cause. Officer Barcel, would you like to make a comment?
No.
And it is now the defense's opportunity to respond and make a short statement, calling witnesses, and testify with respect to probable cause.
And given the recommendation to the top, we do not have any comments as to the first portion of the hearing. We will be waiving that probable cause portion.
So I'm just going to take a short moment. I'm actually going to take a recess. I just want to go review something quickly, and I will let you know my findings.
Okay, thank you.
Thanks.
How have you been, Barstow?
Hey Cooper, how you doing?
All right.
Good.
Ready for the holidays?
Yep. Well, hold on, Cooper.
That's good. What's your name again, Mia?
I'm Attorney Dean, standing in for your attorney, Ms. Jones. Just one moment, the hearing examiner is coming back.
Okay.
Thank you.
Back on the record. All right, thank you. And I am now going to announce my findings. So for charge number 1, condition of reporting, I am making a finding based on State's Exhibit B, double B, and double B. For charge number 2, condition of GPS, I've separated it into 11 separate parts. For part 1 through 10, with the dates of June 14, 2024, June 15, 2024, June 16, 2024, June 20th, 2024, September 12th, 2024, September 17th, 2024, September 21st, 2024, September 24th, 2024, September 28th, 2024, and October 2nd, 2024. I'm making a no finding as the state failed to submit sufficient evidence in support of the charge. I am making a finding of probable cause for charge number 2, condition of DPS, with the date of November 30th, 2024, based on State Exhibit B, D, and double B. And for charge number 3, drugs, I have separated this one into 6 separate parts. So for parts 1 through 5, dated June 26, 24, September 13, 24, September 26, 24, October 16, 24, and October 18, 24, I'm making a no finding as the state failed to submit sufficient evidence in support of the charge. And then in addition, I'm also making a no finding for part 6 dated December 4th, 24, as the state failed to submit sufficient evidence in support of the charge, and specifically with that instance, there's no indication as to what substance Ms. Cooper had used. So those are my findings, and I do find that the acts are not serious enough to warrant revocation, and because of that, your parole is going to be reinstated, Ms. Cooper. The records office at your facility will be notified, and now Officer Barstow is notified of this, and that does conclude the preliminary hearing. Do you have any questions?
So my parole is being reinstated?
Correct.
Yes, ma'am, you should be getting out shortly.
Okay, thank you.
Yes, you should be getting out shortly, okay?
So I should be getting out soon? Like,
Today.
Yeah, most like, yeah, today. They just have to process the information, the records, and then you should be getting out later today, okay?
okay, thank you.
So this concludes the preliminary hearing for Anthony Cooper. You're all set, Ms. Cooper. Take care.
Yep, happy holidays. Thank you.
Take care, ma'am. Happy holidays.
So what time, so class question? So I will go home today though?
It's today. Yes, I'm submitting the paperwork now for today. So everyone will be notified, okay?
Okay, thank you.
Yep. The facility just has to receive the paperwork and then they'll process it.
Okay, thank you. See you later, Barstow.
Take care.
Got my funeral while by herself. So he come to get me, right? Excuse me. Hello?
Ms. Cooper, it'll all be worked out. You're okay. You'll be fine. They'll
Okay.
figure it out. That's their job, okay?
All right,
All
thank
right,
you.
take care, Ms. Cooper. Officer, can we please have Mr. Campbell next?
Okay, Campbell.
Tricia, are we all set or?
Yep, we're all set.
Okay, all right, so
Have a
I'll
good
just
day.
look,
Hmm?
so I'm just gonna be looking out for this information for this reinstate, which is gonna happen today.
No, we reinstated him today, so I'm gonna submit the dispo now, so you'll have all the paperwork you need.
Okay, all right, sounds good, thank you.
All right, thank you.
All right, bye-bye.
Mr. Campbell, we'll be right with you, okay? Okay. Good morning, at Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Paul Campbell, inmate number 422-413. Today is Monday, December 23rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Paul Anthony Campbell, 422-413.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti. Can you please identify yourself for the record?
Certainly. Good morning, sir. Public Defender Robert Famiglietti of the Parole Revocation Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. If You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Campbell, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So we're going to review the procedure for the hearing. You can put your hand down. Thank you. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We will then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After the consideration of all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
So you do have important rights for this hearing, and the first is you have a right to be represented by an attorney, and counsel is here for you. You also have the right to receive a written notice of the charges of violation. Did you receive the written notice?
Yes, I did.
Perfect. You have the right to submit evidence. You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. You also have the right to call and examine any voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So for charge number 1, condition of halfway house, the charging officer reported that on September 5th, 2024, you were smoking marijuana during a halfway house smoke break. On August 8th, 2024, you signed your halfway house agreement, which states that you will not possess or consume marijuana in the halfway house. This behavior violates this agreement. On September 6th, 2024, you returned to the halfway house with marijuana on your person. On August 8th, 2024, you signed the halfway house agreement, which states that you will not possess or consume marijuana in the halfway house. This behavior violates this agreement. On September 21st, 2024, you were smoking marijuana during a halfway house smoke break. You admitted to the behavior. On August 8th, 2024, you signed your halfway house agreement, which states that you will not possess or consume marijuana in the halfway house. This behavior violates this agreement. On September 22nd, 2024, you were smoking marijuana during a halfway house smoke break. You admitted to this behavior. On August 8th, 2024, you signed your halfway house agreement, which states that you will not possess or consume marijuana in the halfway house. This behavior violates this agreement. On September 22nd, 2024, the pat search was conducted by halfway house staff and you were in possession of marijuana. On August 8th, 2024, you signed a halfway house agreement, which states that you will not possess or consume marijuana in the halfway house, and this behavior violates this agreement. On October 7th, 2024, at approximately 8:34 a.m., you walked into the laundry room of the halfway house, threw something at another client's feet, telling them to shut the fuck up. On August 8th, 2024, you signed a halfway house agreement that states that you will treat others with respect and not engage in verbal or physical altercation with other offenders, staff, third parties. This behavior violates this agreement. On October 7th, 2024, at approximately 8:45 a.m., you were observed aggressively walking down the hallway and stepped purposely on another client's foot. A short time later, you came out of your room yelling, "You want some of this? Come and get this if you want some." On August 8th, 2024, you signed a halfway house agreement that states that you will treat others with respect and not engage in verbal or physical altercation with other offenders, staff, or third parties. This behavior violates this agreement. On October 7th, 2024, at approximately 8:54 a.m., you again aggressively walked down the middle of the hallway and made physical contact with another parolee with his shoulders by walking right through him. An argument then ensued and staff separated the parolees. On August 8th, 2024, you signed a halfway house agreement that states that you will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. This behavior violates the agreement. On charge number 2, condition of mental health treatment, on September 24th, 2024, you met with Cheney halfway house staff and your supervising officer. You were directed to attend your evaluation on 10/3/2024 at CRT. On 10/1/2024, when meeting with your supervising officer, you were again directed to attend your evaluation on 10/3/2024. And you failed to attend your scheduled evaluation/medication management appointment on October 3rd, 2024 with CRT. The evidence submitted by the state has been marked and identified at the preliminary hearing, and all those remain the same. So counsel, have you and your client both received the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes.
I have also received an exhibit from the defense, and that's exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Is that accurate?
Yes.
All right, and do you need any time to continue this hearing to obtain more evidence?
No, we don't.
Okay, so today we do not have any witnesses, so at this time it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges or any of the evidence submitted.
I don't have any comment as to the 1, 2, 3, 4, first 5 sections of charge 1, which are merely his using marijuana. As to the parts which all occur on October 7th, which was the date of his remand, that occur over a course of almost exactly 20 minutes. My client had been threatened by someone at the house, and he was merely investigating, stop talking about me, S the F up. He has a right to defend himself. He has a right to inquire what's going on. Why are you talking about me? It takes 2 to tango in here. There were absolutely no injuries. There were no arrests. There's no assault of behavior. I reviewed the 3 brief videos. There's no view of any contact. There's no audio involved. There's no statements from the other party whatsoever. So I don't believe it meets the preponderance standard, whether or not, as the 3 parts, the 834, the 845, and the 854. I don't believe we can prove that any sort of incident occurred and that my client was in fault in any way, shape, or form. That wasn't an investigation. It wasn't an accident. There's no part, or there's absolutely nothing said by the other party. As to the remainder, I made an argument at the preliminary. He went to the Market Street CRT in Hartford. They told him to go to Windsor Street. He was on foot. This was a 30 to 50-minute walk. He decided to return to the halfway house to report the mishap in directions. Those are my comments as to the preponderance standard.
Just going to take a moment and I will let you know my finding. Okay, so for charge number 1, I do find that you violated the condition of halfway house placement based on the evidence provided, which is states exhibit A, D, E, F, G, H, I, and M. And for charge number 2, I do find that you violated the condition of mental health treatment based on states exhibit A, D, K, and L. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you will have the opportunity to speak to your background and history. So counsel, would you like to make a statement?
Yes. The only interventions and sanctions my clients were consuming marijuana. That does not seem to be a reason to reincarcerate someone. It's a reason for treatment. We argued that this violation was not sufficiently serious at the preliminary hearing. This, in our mind, should have been a top. The appeal was leaving it up to the board, is not making any specific recommendations. My client is separated, 42-year-old man. He received support from his mother, father, and brother who resides in the Vernon, Manchester area. He was attending Hartford Reentry Welcome Center for employment assistance. Previously, while on supervision, he was a full-time selector at AD USA in Tolland, on Tolland Turnpike in Manchester. He was there for a number of weeks. After that, he has participated in outpatient services, including anger management once weekly and about 2 individual therapies and sessions at CRT. He's participated in the CTPSB program. He has had anger management treatment in the past at Wheeler Clinic. He worked with case management services at CRT. He also met with therapists in the Scripps program. He's currently on the waiting list for the ART program. While incarcerated, he would like to be placed in a halfway house in Hartford because it's close to his support system. He would like to enroll in trade school to study either welding and or CNC machining. Like I said, I don't believe that these violations are serious. On January 7th, he will have sat 3 months for this violation. I think that that's enough time for him to serve. I don't believe that any interest of society or the criminal justice system are served by incarcerating him longer for these incidents. Thank you for your time and consideration.
Thank you. I'm just gonna take a moment, then I'll let you know my recommendation. So I have listened to the testimony today and I reviewed all the evidence that has been submitted. Based on that, I am going to recommend your parole be revoked, Mr. Campbell, and that you serve an approximate 5-month period of confinement as a sanction. That's with a re-parole date of March 7th, 2025. In addition, I'm going to recommend the following conditions: halfway house placement, heartburn, here, mental health treatment, no consumption of alcoholic beverages, no contact with victims NL and AL, no contact with minors, problem sexual behavior treatment, a general no contact with EQ, and behavioral management program, anger management. You said you were participating, correct? Have you completed it yet?
Say
You
again?
did not complete. Did you complete the anger management program, or you were just participating in it at the time?
I think he's completed at least one anger management. What's that?
Yeah. No, I wasn't,
You completed it
I did
once?
not. I completed it once and I started, I completed it once and I started it again.
All right, so I am going to do a behavioral management program for anger management. So those are my findings that are going to be forwarded to the board on January 9th, 2025. You'll receive an official written decision from the board shortly after that date. At that hearing on January 9th, the board can lessen my recommended sanction. They can let my recommended sanction stand, or they can impose a sanction longer than what I've recommended. If they do recommend a sanction longer than what I've imposed, there'll be a supplemental hearing and you'll be present for that and you'll be notified of the reasons why. That way they can address it with you at that supplemental hearing if that's what happens, okay? Do you have any questions right now, Mr. Campbell?
No.
So she's recommended March 7th. The board can shorten that and the board can lengthen that. And they will make their decision on January 9th. So give us a call on January 10th, okay? Okay, so have a nice day.
This concludes revocation hearing for Paul Campbell, inmate number 4222413. All right, you're all set, Mr. Campbell. Thank you. Thank you, Attorney Famiglietti. Yes, please. Thank you.
Bolan?
Yes, please. Oh, thought you were asking me.
It's been a long day, I know.
It has been a long day, and it's still the morning time. So good morning, Mr. Bolan. I am Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning you, Matthew Bolan, inmate number 352-006. Today is Monday, December 23rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Can you please state your full name and inmate number for the record?
Matthew Bolan, 352-006.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. So we're going to go over the purpose of today's hearing. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will be given to the panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will also be taken under oath. So, Mr. Bolan, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
So we're going to go over the procedure for the hearing. The first is that you have, I'm going to read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state's not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After the consideration of all the evidence presented, I will announce my findings. And if I finally have violated one or more of the conditions of your parole, you'll have the opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights at this hearing, and the first right you have is to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that attorney could represent you at today's hearing?
Yes, I was.
Okay, do you intend to seek counsel?
No, I'm just going to represent myself.
Okay, so I'm just going to probably confirm a few more times. So you're saying as of today, you're okay with moving forward without any legal representation?
Yes.
So you also have the right to receive written notice of the charges of the violation. Did you receive the written notice?
Yes, I did. Yes.
And you have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of the case. You also have the right to call any witnesses and examine any adverse witnesses. And those are your rights for today. Do you understand these rights, and are you ready to go forward?
Yes, I am.
So we're going to review the charges that the state your parole officer is bringing against you and the underlying information for each charge. So for charge number 1, condition of reporting, the charging officer reported that you failed to report with parole officer as directed and scheduled upon your release from the App Foundation on 8/14/2024. You're aware of your report date and signed a parole release authorization with your Apt Foundation clinician on 8/8/2024, acknowledging that you were informed and understood your reporting instructions. You did not make any attempts to contact your parole officer to report any issues or barriers to reporting on that date. Based on this information, you're in violation of standard parole condition 1, release direction. On charge number 2, condition of obedience to the law, the charging officer reported that on August 17, 2024, per Connecticut State Police, Troop C, you drove a vehicle under the influence of alcohol and/or drugs, resulting in a motor vehicle accident. You reportedly failed to stay in your proper vehicle driving lane, swerving repeatedly, going off the roadway on both the left and right sides, causing damage to several mailboxes, and eventually colliding into a telephone pole. Per the trooper, your vehicle sustained disabling damage to the front end, and you then fled the scene on foot. You're apprehended a couple miles north of the accident scene and determined to be under the influence of alcohol and/or drugs and transported to Wyndham Hospital for evaluation. Subsequently, you were arrested and charged with the following: Connecticut General Statute 14-224B3, evade responsibility, injury, property damage, Connecticut General Statute 14-227A, illegal operation of a motor vehicle under the influence of alcohol and drugs, Connecticut General Statute 53A-167A, interfering with an officer resisting, and based on your behavior, you violated the standard parole conditions of obey all laws. On charge number 3, condition of drugs, the charging officer reported that on June 3rd, 2024, you admitted to using alcohol and cocaine. You signed a voluntary admission form and were issued a misconduct. On June 27, 2024, you admitted to using cocaine. You signed a voluntary admission form and were issued a misconduct. On August 17, 2024, per Connecticut State Police, Troop C, you were found to be driving a vehicle under the influence of alcohol and/or drugs. Based on this information, you are in violation of the standard parole condition 2, obey all laws. In charge number 4, condition of parole, no consumption of alcohol, the charging officer reported that on August 17, 2024, per Connecticut State Police, Troop C, you were found to be driving your vehicle under the influence of alcohol and/or drugs, and subsequently arrested and charged with the following: Connecticut General Statute 14-224B3, evading responsibility, property damage, Connecticut General Statute 14-227A, illegal operation of a motor vehicle under the influence of alcohol, drugs, Connecticut General Statute 53A-167A, interfering with an officer resisting. Based on this information, you are in violation of your condition of parole, specifically additional conditions of no consumption of alcoholic beverages. I want to make a note that charge number 3, drugs, that charge was identified as 3 parts at your preliminary hearing, and then no finding was found in regards to the 3rd part, which is dated August 17, 2024. So that part was not taken into consideration at today's hearing, okay? The evidence submitted by the state was identified and marked at the preliminary hearing, and those all remain the same. I'm also identifying new evidence submitted, which is the case information screen as State's Exhibit M. And in addition, the state has filed an addendum to the parole violation report, and they submitted that on November 19th, 2024, and it states as followed. On November 13th, 2024, Matthew Bolan, inmate number 352006, was sentenced on docket T19R MV 24-0277193-S and found guilty on 14-227A, illegal operation of a motor vehicle under the influence, and received a sentence of 30 days jail, $500 fine, $500 remit. On charges of 14-224B3, evading responsibility injury, that was nullied on that date. And on the additional docket heard on the same day, T19R CR24-0189191S, the charge against Mr. Bolan for 53A-167, interfering with an officer, was also nullied. Supporting documents were loaded into case notes. So, Mr. Bolan, did you receive the notice of parole violation, the parole violation report, and all the other documents that have been identified for today's purposes?
Yes, I have.
Okay, and I have not received any exhibits from you. Is that correct?
Yes.
Do you need more time to submit any evidence for your behalf?
No.
So we do not have any witnesses at this time. So it is your opportunity to respond to the parole violation charges against you. However, remember, you may remain silent if you choose to do so. So at this time, would you like to testify regarding your case or the preponderance standard for the charges?
Just that I take full responsibility for my actions, and I'm trying to work with the people that I was working with before I went to the App Foundation for substance abuse treatment, and my family found a sober house that has beds available that'll take me if you guys decide to release me. I've actually mailed that to the parole counselor supervisor, received that information already for the sober house and stuff. So, but other than that, I just take full responsibility. So.
You. You mentioned you want to work with people at the Fiak Foundation or somewhere you worked before?
No, there was a program, the PHP program that I was in before the App Foundation, that my parole officer had put me in. I'm not sure the name of it, but I know it was the PHP. I was working with them. It was in Manchester.
Manchester?
Yeah.
So you're willing to go back there and work with them?
Yeah, and then be placed in a sober house that I already mailed to the parole people and everything, that they're already aware of it.
Thank you. So I am going to announce my findings then. So for charge number 1, condition of reporting, I do find that you violated your condition based on State's Exhibit A, D, and J. On charge number 2, I find that you violated the condition of obedience of the law based on your conviction of the Connecticut General Statute number 14-227A, illegal operation of a motor vehicle under the influence, on November 13, 2024, when you received a 30-day jail sentence with a $500 fine and $500 remit. In addition, the evidence to support the charge is Exhibit A, D, and E. On charge number 3, I find that you violated the condition of drugs based on the evidence provided in Exhibit A, D, G, E, and H. And on charge number 4, I find that you violated the conditions of no consumption of alcoholic beverages based on the evidence provided in the charge, which is Exhibit A, D, and E. So that does conclude the fact-finding portion of this hearing. I have heard what you said, that you take responsibility, you have the plans to go to a sober house, and you want to work with that program in the community. Do you have any other information that you want to provide for your background history before I make my recommendation?
No, that's it.
So based on that, I have listened to the testimony today, and I did review all the evidence provided, and I am going to recommend that your parole be revoked and you serve an approximate 6-month period of confinement as a sanction. So that gives you a re-parole date of February 17th, 2025. In addition, I'm going to recommend the following conditions: no alcoholic beverage consumption, no contact with your co-defendants, Josh Bragdon and Nick Neal, no contact with your victims, BS, HC, TL, SD, SB, EB, MBC, a general no contact with Bird Dog Liquor in Mansfield, a mental health evaluation, and no operation of a motor vehicle without your parole officer's permission. I'm also just going to do halfway house just in case, because you're on special parole, correct? Are you on a special parole?
Yes. Yeah, I'm on
So
special.
if the board adopts that date, you have to be released that day. So if there's issues with you getting into the sober house, just so that they have somewhere for you to go, okay? So that is my final recommendation. I'm going to forward them to the board on January 9th, 2025. That date, you'll receive a written notice about a week or so after that date with the final decision from the board. Just so you're aware, on that date, the board can do a few things. They can lessen my recommendation, they can adopt it and accept it, or they can increase it. If they choose to increase the sanction longer than what I've recommended, you'll be notified of a hearing that's going to be held. And you'll also be given the reasons why they want to increase the time, and you'll be present to address any of their concerns before it happens, okay?
All right.
Do you have any questions as of right now?
No.
Okay, so then you were all set, Mr. Bolan, and happy holidays, okay?
All right, thank you, you too.
Take care, have a good day.
So.
This concludes the revocation hearing for Matthew Bolan. Thank you.
Merry Christmas.
Happy
Have a
holidays.
good one.
Merry
Thank you
Christmas.
too.
Happy New Year.
Merry Christmas. You too.